Hello everyone, I'm Professor Paul Carrier, and what I'd like to do now is to continue consideration of the issue of contract interpretation. Recall, when there is a term in a contract that has two different meanings and the parties are fighting over it, if that term is unclear, if that term is ambiguous, then a court will engage in the process of interpretation. And there was a previous segment where we discussed that, and we provided information on what we believe is the best framework for handling the various rules that courts may use for contract interpretation. What we'd like to do here, and this is unique to some degree to our approach, is to provide some more specific examples of a particular rule. And these rules will be set out, or are set out, most clearly in the Uniform Commercial Code, which is probably your state law. So remember, the states have adopted in significant detail the Article 2 of the Uniform Commercial Code, many without significant change. So if you looked at 2-, you also looked at UCC Article 1, so 1-103, you'd see that there are three concepts on how to, three tools for interpretation, all involving facts extrinsic to the paper, okay? Let's see. Before I go into an explanation, I want you to understand that even though this is best addressed by the Uniform Commercial Code in Article 2 and that Article 1 definitions area, the same ideas can be used in common law cases as well as in sale of goods cases. And if you wanted to verify that, you could take a look at Corbin, you could take a look at the Restatement Second of Contracts. And let me briefly say where we are. When you look at a contract interpretation, our framework starts with the goal, determine the intent of the parties, then the rules to be used. And our hierarchy goes from least extrinsic to most extrinsic. First one, least extrinsic, is the plain meaning rule, where a court, with its knowledge and perhaps with a dictionary, will take a term that looks ambiguous and say that it's actually not. It's plain, everyone knows what these means, one of you is probably lying, I understand it, done. Okay? If a court's not comfortable in doing that, or if the court chooses not to start there, the court could jump to the second, slightly more extrinsic four corners rule. And that is where a court could look at a term, if it's ambiguous, and then look at the rest of the agreement. Maybe another clause later has a more clear definition of the same idea. And then that ambiguous term can be interpreted using the one somewhere else in the contract. For example, if clause 11 says green and clause 15 says lime green, chances are the clause 11 green was intended to be lime green and not forest green, okay, or hunter's green, as an example. The third, more extrinsic, are rules of construction, where courts can apply long-standing intelligent truisms. For example, construe a term against the drafter because it's the drafter's fault that there's an ambiguity in the first place. The fourth, and now we're getting into something extremely extrinsic, is where courts, using what I like to call a holistic approach, will look at everything: the contract, the emails before the contract, telephone conversations, brochures from last month, brochures from last year. Anything that relates to that contract, a court can look at and balance each item's evidentiary value, and on a holistic level, determine what an ambiguous term meant. But you see why that's so very extrinsic. It's not just looking at the word. It's not just looking at that word and other terms within the same document, right? It's not even looking at, unrelated to the contract, these legal truisms, for example, expression of one thing excludes others, or construction against the drafter. It is looking at ads. It is looking at prior emails. It is looking at prior deals. It is looking at how the industry does it with other parties. And so it's a very large grab bag of information that a court can sift through to determine what an ambiguous term meant. And so again, the secret is it is very, very extrinsic. But parties' actions can often provide information on what was intended, okay? And there are three basic ones. The first is course of performance. If the parties, and think about it this way, same parties, same transaction. 3 weeks into a contract, the parties are arguing over a term. What did they do the week before and the week before that? Do their activities in performing the contract help us to determine what they intended, even though now we have a conflict? What did they intend and how did they perform before that conflict arose? And that may tell you what the parties intended, even though now there's a dispute over what that means. Second one, course of dealing. That is same parties, different transactions, usually prior. I think almost always prior. Imagine this. Businesses work on a yearly basis. They're going back and forth doing business deals. There's a problem. A new manager comes in. New manager doesn't like something. The new manager argues that this term's ambiguous and we're going to interpret it this way, not that way. We have a dispute. Question. How did the parties treat that term in last year's contract or the contract 2 years ago? Because how those parties were doing it in the past can help us determine what they intended when they signed these agreements. There's a dispute now, but what they intended as they're moving along is proof. But remember, course of performance is same parties, same agreement in their performance. Course of dealing is how they've done it before in similar contracts between the same parties. Okay? The third one, usage of trade. You may have other competitors in the business, in the industry, okay? And everyone in the business for more than 6 weeks knows how things work, knows how the industry works, okay? And so if someone's in the business, he or she is probably aware of what all the other competitors and all the other people doing the same business treat certain terms. So you can look at different parties and how those parties interpret a particular term, and you can use that as a guide, as a tool to interpret a term that is between the two parties in front of a court, an ambiguous term, or an arguably ambiguous term, okay? And you see, even that goes from least to most extrinsic. Least extrinsic is the same parties in the same transaction and how they are acting, okay? A little more extrinsic is how the parties acted in another transaction a year ago, 3 years ago. Very extrinsic is how other parties in similar but different contracts do things and how they interpret things. And that's significantly more extrinsic. So you can even put these in a hierarchy from least to most extrinsic, all right? And courts often do not define on this extrinsic scale, which is what we're introducing, we believe, as a new framework to impose upon these rules and to provide a little bit more background and understandability. If that's not a word, it should be. Copyright, Professor Carrier, 2018. Okay, now, briefly, if someone argues ambiguity and there's a term that's pretty clear, chances are a court will stop right there. If it's more arguable, a court might look at four corners, right? If that doesn't work, a court could go to the rules of construction. And remember, if courts don't like it, they can even skip the first 2 or 3 tests and go right to it. There's nothing that I have seen, that we have seen, that requires a court to go to the plain meaning rule first, although it probably should. And failing that, go to four corners. Probably should. But until now, no one's really tried to corral the thinking into least to most extrinsic. The court could go right to this fourth test, this holistic approach, right? And skip the other ones. Or the court could just pop right to rule of construction and use one that fits. Let's give an example now. Examples, if you don't have an example of something, and this is why our book includes this chapter. We want to show people what our course of performance, course of dealing, and usage of trade. Let's talk about course of performance. Let's say that a contract is made a month ago, and the parties in the agreement don't make clear in their agreement who has the risk of loss as something is being shipped, let's say, across the ocean. Okay? One's when the ship goes down with the goods. One says that's your bad, and the other says no, that's your bad. And both fight, and now we have a term that isn't particularly clear on who bears that risk of loss. It might be mentioned, but it's not fully clear. why don't we look at what the parties did, right? Did the shipper, did the manufacturer who's shipping it to the buyer call up its insurance company and add a rider to cover those goods, all right? And then maybe the insurance company, the premium wasn't paid, so it wasn't actually insured properly. Now the shipper's going, or now the supplier who's shipping it, or the manufacturer shipping it, is going to argue, we didn't bear the risk because it doesn't have insurance coverage for failure to pay insurance bill or invoice. But you could see in my facts where the supplier, the manufacturer who's shipping the good to the buyer, actually tried to cover it under its own insurance policy. So, same parties, same transaction. They called the insurance company and tried to add a rider. Didn't work, but you see what the intent was when they called the insurance company, right? We're responsible for that. Add it to our insurance policy. So there's an example of course of performance. Now let's talk about course of dealing. That would be same parties, different transaction. Let's just say that in the old days, the contract required shipping within a reasonable time, which has a little wiggle room in it. What does reasonable time mean? Now there's a fight, and the buyer demands that the shipment is within 3 days of invoice, or 3 days of delivery of the purchase order. That could be relatively extreme. And the other party would argue, wait, we have never defined the shipping date as 3 days after we receive the purchase order. It's always been a little bit more flexible than that. What do you mean you're canceling the contract and you're going to another supplier and you're leaving us? That's a breach. You can't do that. And so the ambiguity would be over what is intended with the delivery or the shipment term. And we can look at what the parties did the year before and the year before that. What if shipping was always by the end of the month an invoice was delivered? Maybe that practice from past or prior contracts between the same parties will explain what they intended when they signed this particular contract. And one is now taking an unreasonable position. So that, again, same parties, different transactions, course of dealing. Now let's talk about usage of trade. Let's just say there's a term and there's not a lot of prior dealings between these parties. There's no course of performance yet. Maybe the breach came early after the contract was signed. But both of these parties have been in the business for decades. Why can't we look at what one of those parties used to do with other contractual parties? Suppliers ship to 15 or 30 different buyers. What do they use? How do they operate with other buyers? You can even look at competitors, dealing with other competitors. What is standard in that industry? What does everyone in the industry know this term to mean? For example, let's just say that there's an order for iron ore, and it's in tons, T-O-N-S, right? And then at some point, to gain some advantage, one of the parties argues that tons, T-O-N-N-E-S, is actually what was intended. The first ton, 2,000 pounds. The second ton, T-O-N-N-E, is, I think, 2,200 pounds. Okay? So those words similar, but they actually, in the industry, have different meanings. One is 2,000, one is 2,200. And if the parties, or let's say they misspelled tons. What if it was spelled T-O-N-E-S? It's not T-O-N-S, it's not T-O-N-N-E-S, it's T-O-N-E-S, tones. Now, that's clearly ambiguous. What did the parties mean?